Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence and specifically the policy rules under the Federal Rules, Rules 407 to 411, and specifically today, Rule 408 that has to do with compromise offers and negotiations. And really what we're talking about broadly is settlement negotiations in civil cases. The policy, if you start with why do we need this rule, the policy is we want people to have free-flowing conversations in pursuit of settlement in civil matters. That is, we want them to speak freely, we want them to offer, we want them to accept, we want them to counteroffer, we want a back and forth to promote settlement, otherwise our courts will be clogged. So if you look at this rule, it really envisions this ideal circumstance of a settlement negotiation. So I want you to picture the way that it's supposed to work. Imagine a plaintiff with their attorneys are making their way to a conference room in some building and meeting up with the defendant and his or her attorneys, and everyone's got their suits and briefcases, and they enter into that conference room for the express purpose. You can almost picture the sign on the door, settlement negotiations in the case of plaintiff versus defense today. Well, just imagine that upon entering that conference room and upon having that discussion that you've entered into this bubble. And not only is it that defendant, the word comes out of their mouth and says, hey, I'll offer to settle this claim for X amount of dollars and do this. And plaintiff says, nah, I don't think we're going to do that today. That offer is protected. A counter demand is protected. All the back and forth that you learn about in contract law of offers, acceptance, it's all protected in that bubble and can't be used in subsequent litigation when the settlement negotiations break down and we eventually proceed to trial, because we're talking about a federal rule of evidence. We're talking about a trial rule. But it's also broader than that, as you'll see in an important part of the rule. Every statement that's said within that bubble is also protected. So one of the ways you have to think about this is it's not only, hey, I offer to compromise or settle this lawsuit for $100 million, plaintiff rejects it, that offer is not going to be involved. It's also, listen, we know we did a bunch of things wrong as the defendants in this case. We want to make it right. We want to move on and allow you to move on, plaintiff. That statement can't be used as well. So the offers and acceptance, and of course, just like every other policy rule, there's good purposes and bad purposes that are part of the foundational requirements. So if you look at the rule up first, here's the essence of the rule. To prove or disprove the validity of a claim, that has to be a claim, it has to be in dispute. We can't let out furnishing, promising, offering to compromise claim. So settlement offers, accepting, promising, offering to accept, every variation you can imagine can't be offered for the bad purpose to prove or disprove the validity of the claim. Look, the plaintiff would want to say at trial, look, they offered me $100 million to settle this claim. Of course that goes to prove the validity of this claim before this jury. So that would be the 1, 2, 3 foundational requirements of the objection for the opponent when they are objecting in the ring, when they are throwing the flag for Rule 408, compromise offers. The opponent would stand up and say, objection under Rule 408, compromise offers and negotiations. I have the foundational requirements. There is a claim here. It's a disputed claim, and they're doing this thing. They're trying to offer part of the compromise, part of the discussion, part of the furnishing, promising, or offering, or accepting, promising, or offering to accept to compromise the claim. They're offering that here to prove the validity of the claim here at trial. So that's the 1, 2, 3, including the bad purpose that's owned by the opponent. And as we've learned throughout these policy rules as it relates to 407 and 409 for offer to pay medical expenses, 411 as it relates to liability insurance, 408 is no different. The proponent has a part of this rule too. They explicitly set out in the rule subpart B exceptions. So you can't offer these settlement negotiations and these settlement offers and demands and counteroffers for the purpose of proving or disproving validity. That's the bad purpose. That's why we need the rule, because we want free-flowing settlement conversations. But you can introduce it for some other purpose. And the big one, and the one that comes up in tests, is a purpose of proving a witness's bias or prejudice. So imagine if I have 2 defendants. One settles out for a reasonable amount, but then all of a sudden is a witness at trial in the remaining defendant versus plaintiff trial. Well, we're going to be able to explore in cross-examination. You're sitting here and you're testifying today, once a defendant in this action, but you're testifying on behalf of the plaintiff. And isn't it true that you settle with the plaintiff and maybe they paid you a little bit more than your claim was worth? So you're trying to set up that that witness, that former defendant, has some kind of bias, some kind of prejudice in the lawsuit. So you get to bring up, the idea of settlement, the idea of those negotiations for the purpose of not proving or disproving the validity of the claim, but showing a witness's bias. And then there's the real expansion, real important part of the rule, the most readily tested part of the rule, and that is it does not just cover offers to settle and promises to settle and counter offers to settle and promises to accept. It doesn't cover just the formal language of reaching a settlement agreement, which is essentially reaching a contract. Once you're in that bubble, you go into a conference room, there's a claim already filed, we have our lawyers, we're having a day of settlement negotiations. Everything that's said in that room is also protected. Conduct or a statement made during compromise negotiations. And the only reason they include conduct is something we'll talk about it in hearsay. It's that when conduct's intended as a statement. If someone says, Mr. Defendant, you're responsible here. You did everything, didn't you? And he goes, yep, thumbs up. Doesn't say anything, but his conduct clearly is meant as a statement to say, yes, I agree with what you just said. So all the conduct intended as statements and the statements that are made in negotiation are going to be included. Now, there's a real narrow exception in subpart 2 that has to do when it's a criminal case in a regulatory agency like FCC or SCC. When statements are made there, they may be able to use. Really difficult to test. Just know that little exception to the conduct and statement. But take this conduct and statement, the broad part of the rule, it's not just the offers to compromise, but also any statement made while in that bubble of settlement negotiations, and then look at that first part of what's also prohibited, to impeach a prior and consistent statement. So just think about that. That is prohibited. Most of the time in most of these rules, you can use things to impeach. We saw impeachment come up in Rule 7 of subsequent remedial measures as an other purpose, a good purpose that could be available to the proponent who's putting on this evidence to say, no, I'm not introducing it for the bad purpose to prove liability. I'm offering it for a good purpose, here to impeach. Here, impeachment is part of the prohibited uses. That means just because a person says different things on different days does not mean under this rule that I get to bring it up. We want free-flowing conversation. So if the defendant says, listen, I'm responsible for this lawsuit. I'm responsible for this. I did it. I've been careless in the way that my trucking company has been delivering your goods for a long time. I'm sorry. I need to do better. We got to figure out ways to do better. I hope we can settle this lawsuit. That settlement negotiation inside that bubble breaks down. We go forward to trial. And on the witness stand, that same person that was in settlement negotiation is now a witness at trial. And at trial, under oath, on direct examination, says there's nothing we can do that could make this any better. I take no responsibility, and I don't think there's anything that we could do to make this better. Obviously, that's saying two different things on different days, but it is a prohibited use to take one of the statements that are made in that bubble and try to use it to impeach. So it would probably be a motion in limine should it happen. It would definitely be, but you can't impeach in this circumstance. That's how badly we want to protect that which is said in the bubble. Be real careful as it relates to this rule of making sure there's a claim. So look out for preliminary discussions. If it's just one party to another, essentially before there's a lawsuit saying, hey, can we just figure this all out? Can I pay you a couple $100 and we make this whole thing go away? Well, maybe there isn't a claim yet. Maybe they haven't filed a lawsuit yet. Maybe they haven't sent a letter through attorneys to say, I'm making you aware of the prospect of a lawsuit. That's what we need for a claim. So watch out for those preliminary discussions and make sure the claim's in dispute. Make sure it's a typical type of lawsuit where there's something on either side, that it's not just a concession disguised as a lawsuit. So you need a claim, you need to dispute it, and the bad purpose is to prove or disprove the validity of that claim, or as we just talked about, to impeach by prior and consistent statement. Imagine and demand that bubble. Imagine that there's a day of settlement negotiations that are protected under Rule 408. and that you're protecting everything that's said between the parties, the statements made during negotiations, and of course the offers and promises to accept and all the things that go along with the contract of a settlement negotiation. In practice, just footnote here, the way you do this is when you write a letter that's settlement negotiations or you're having a discussion on a certain day of settlement negotiations, you clearly and directly implicate Rule 408. Protect the following conversation is protected by Rule 408. Are we all in agreement with that? Yes, yes. That way there's no dispute, and there's no dispute that anything that happens that day is going to fall within the parameters of this rule.